Got into a small fender bender and I'm being told I owe 20k. Hello, so I really need some advice. So about 3 years ago I got into a fender bender, didn't see traffic come to a stop, accidentally rear-ended someone going about 20-25 give or take. He was in a relatively newer Toyota truck, and sustained the least damage, barely looked like I dented his bumper, whilst the front of my car got a fair bit of damage. Anyway, we both got out and swapped insurance and such, took pictures, made sure we were both okay. He said he was fine and nowhere hurt, etc. Then we went our separate ways. About 2 years go by and I got a court summons. Debt collectors saying they've been trying to get a hold of me, which they hadn't, and I'm told I owe 20 grand. 10k for vehicle damage and 10k for hospital bills. A bit of relevant info: I was using my mother-in-law's car at the time. I was under the impression they had full coverage, they didn't. Therefore, because I was driving, I wasn't covered on their insurance and I have to pay 20k out of pocket. This is where I need legal advice. Is there any way to settle for less? All things considered, 20k seems a bit steep. Any help would be appreciated regardless if I'm wrong or not. I'd mostly just like to understand, see what my options are here. Edit 1. Wow, thank you all for your advice. I'm filing most of it away. So, to answer some widely regarded questions. Yes, I did live with them, but not officially. I technically wasn't supposed to be living there, so I wasn't on the lease and had a separate mailing address. I did also check the statute of limitations, and in WA state, it's 3 years, lucky me. I did want to clear this up for a better understanding. While it was easier to say, my mother-in-law was actually just my girlfriend's mother, as me and my sir weren't actually married. Not sure if it actually mattered. And finally, as per most recommended, I found a place near me that does free consultations, so I'm going to give them a call when they open. After that, I got the name of the insurance, so I'll be following up with them after. No, I did not have insurance of my own at that time, as I didn't have my own car, but yes, I did and still do have a legal driver's license. Why were you not covered by insurance? There was no insurance at all on the car you were driving? What happened in court? You need a lawyer. The court summons suggests you've been served and need to prepare for court. The mention of debt collectors suggests that there is a judgment against you already. Either way, an attorney will be able to help you take the appropriate next steps. If you have AAA, you can get a low-cost lawyer through them. The first thing that came to mind when reading your post, which is what someone else mentioned, is the in-laws are lying about their insurance not covering you. They're probably afraid their rates will go up if the accident is reported. Good luck. Unless their insurance specifically excluded you by name, you are covered by it when you're driving their car. And if you have insurance in your own name on a different car, that can be used as backup. You need to get a credit report and look for these collection accounts. I'm betting they don't exist. I think you are being scammed. If looks like a duck, walks like a duck and quack likes a duck, most likely it is a duck. And your case is a quack. Talk to some lawyer, or even better, ask them for all proof they have, then talk with a lawyer and find out what exactly is going on, and please, come back here and tell us. Please verify this debt with the court prior to any action. There is a scam which is very similar to this with information obtained by public records. Verify information through your own sources, not their, prior to acknowledging anything. Reading this, it seems like there was already a default judgment against you. Maybe they served an old address. If it was improper service, you would need to get a lawyer to fight it and reopen the case. This may end up costing more than 20k. Either way, you need a lawyer though. Seems like a scam. If you know that court was a few months ago, then call the courthouse, give them your name, and ask for a copy of the judgment. If there is no judgment against you, then there is no debt. Start there. I'm a California lawyer. My advice is to call your auto insurance. They will fight for you and hire lawyers to defend you if needed. Check your state's statute of limitations. In CA, it's only 2 years for negligence causing bodily injury, so if he didn't file the lawsuit within 2 years you can beat that claim. Property damage has a 3-year statute from what I recall. Good luck edited solve for CAPD. You need to get a record of all attempts to contact you from the other insurance and collection agencies. They need to prove that they actually made the efforts to find you. You need an attorney to at least look at your case and find out when the claim was first made against you. If you exchanged information, as you claim, and there were no changes to yours, then they need to prove honest attempts were made to contact you. If you lived with the person who loaned you the car and weren't on the policy would exclude you from coverage. It sounds like you went to court so the debt is proven. If not, you could ask for proof of debt from the collection agency, but it seems like they have proof. You could try to settle. The lawyer is obligated to tell their client of a settlement offer, I think. You'll probably want to have your own lawyer to help navigate this. Summons is a lawsuit. Debt collector implies already a default judgment against you. Which is it? I would get an attorney. This just smells wrong in so many ways. 1. I imagine your relatives never reported the accident to their insurance. 2. If you had no idea that any lawsuit was filed, I suspect no one tried to reach you. 3. Anyone can sue anyone at any time for any just smells like a scam. You need the facts, so far there is just a bunch of they said. I'm confused as to why debt collectors are trying to get money from you. If the guy from the accident incurred medical costs, he'd be responsible for paying them, and then he'd have to sue you to recover those costs. I would think the same goes for damage to his vehicle. If your in-law's insurance didn't cover it, he'd be paying for it himself, or his insurance would pay and then sue you to recover the costs. Did you have a driver's license at the time? This may seem like a stupid question, but I was struck by an unlicensed driver who had borrowed her husband's truck. Unlicensed drivers cannot be authorized users as it is illegal for them to operate a vehicle. The insurance company will refuse to cover you in that situation. Is it on your credit report? If not, tell them to go blow a goat. If it is, dispute that with the bureaus and see what the result is. Insurance follows the car. It should have been covered because they gave you permission to drive it. You received a summons 2.5 years ago and you're trying to figure out what to do now? Did you or your mother-in-law report it to insurance? What the hell has been going on for 2.5 years? I own a Toyota and have been rear-ended before. The truck was filled with camping equipments and we were rear-ended at around the same speed. At first damage looked minimal, just the bumper being a little bent. In truth, what actually happened, it is compressed and bent the whole frame, and it was bent like a banana. We didn't notice for about a day till we unloaded the gear and the bed was cracked. This is likely what's happening with this claim. TLDR, likely much more damage was done than initially inspected. What state are you in? Did you live with the owner of the car at the time of the accident? Not staying on their couch for a few days but haven't mail delivered there? You need to contact the insurance again and appeal if you were not officially living there. They should cover you. Otherwise you will owe $20,000 and will have to pay it. No, your in-laws don't want a claim on their insurance because their rates will go up. Or are you under 25? A lot of insurance companies do not cover guest drivers under 25. Either way, you can always negotiate a settlement for fractions. Especially if you are willing and have the funds to just settle the debt. But contact your in-laws' insurance agent, see if they sent out anything to the in-laws. If the in-laws kept information from you and don't want to open a claim, even though that is what insurance is for, maybe they would be willing to help settle the debt. What about statute of limitations? Does that apply here? Which state are you in? Albert work in insurance. Unless they have you listed as an excluded driver, then their insurance should cover you. It's called permissive use and it means that you're covered as long as you had their permission to use the vehicle. They need to call the insurance and tell them it was permissive use and that they need to cover it.